So again, thank you. I'm the campaign manager for Oklahomans for Food, Farm, and Family, which is an umbrella organization consisting of the Oklahoma Municipal League, has 460 cities and towns across the state of Oklahoma, the Oklahoma Farm and Food Alliance, which is over 450 local food producers, restaurants, grocery stores, and distributors that all use local foods. And then we're also organized with the Conservation Coalition of Oklahoma. They're a sub-umbrella group that represents Trout Unlimited, Ducks Unlimited, Quail Unlimited, mainly hunting and fishing organizations. So the three focal points of our organization are cities, food, and conservation. The proponents of this bill, if you guys aren't familiar with State Question 777, it's the so-called Right to Farm constitutional amendment. What it purports to do is create an exemption from new laws and regulations for the agriculture industry. So if you're an attorney like me, that raises flags right there. When you have an industry asking for special treatment over any individuals or any other industry, that's a major red flag. And that's enough to vote it down right there. As it should be. But the proponents will tell you that this is necessary because the agriculture industry is somehow under attack from animal rights organizations. I propose to you this. In the last 10 years here in Oklahoma, there has not been one single proposal to restrict animal care, handling, anything at the municipal level, at the state level. It may be at the federal level, but what this proposes to do is to modify Oklahoma's constitution to prevent us from passing any laws and regulations impacting the agricultural industry. So here, there's no justification for it in Oklahoma. There's been zero efforts. And you can ask the supporters to provide proof of that. All they'll be able to do is point to California, where the voters, not special interest groups, but the voters of the state of California passed Proposition 2, which required poultry, livestock, et cetera, to be raised in pens where they can at least get up, turn around. Well, they'll tell you that it's wreaking havoc. The eggs cost $8 a dozen. There was an article yesterday in the Woodward News where the reporter called out to San Diego, very expensive community, and spoke to the Kroger's there, their grocery chain. How much is the price of a dozen of eggs? $2.57. She calls Woodward's United Supermarket. How much is a dozen of eggs? $2.79. So it's more expensive here in Oklahoma than it even is in California. So this idea that the sky is falling and agriculture is under attack in Oklahoma is preposterous. It's what it really is it's big agriculture, the big agrochemical companies who are funding these campaigns nationally. Monsanto, Cargill, et cetera. They're the ones putting all the money into this, seeking exemptions from the law that we are all subject to. Right there, that should be enough. I should be like, all right, thank you very much. You guys have a great evening.
We call that crony capitalism.
It absolutely is. This is part of that corporate welfare state. And what they're doing a really good job of is wrapping themselves in the shroud of the family farmer. They've got the guy out on his combine and they say, you know, we need these protections. But what it really is, it's those giant pork companies like Smithfield, which is the largest pork producer in the United States. They have over 50,000 sows in Oklahoma. Who owns Smithfield? The Chinese government. So who's really promoting this? Who's asking to be able to be free from restrictions in Oklahoma? Right there. The proponents will tell you that 98% of farms in Oklahoma are family owned and operated. That may be the case. But according to USDA Ag Census data, see, we actually back up our arguments with facts and figures, and we can't get them to do it. So the USDA Ag Census data will tell you that 90+% of pork produced in Oklahoma comes from less than 2% of those farms. So where is it coming from? Those Smithfield operations. So while 98% of the farms may be family owned and operated, who's really generating most of the food? Who's having the biggest impact on the food system? It's these large corporate interests. So that right there, again, should send up major red flags. There's a big difference. So in 2012, we voted to adopt a right to hunt and fish constitutional amendment. Sound idea. It was basically the concept that, hey, we support the right to hunt and fish in Oklahoma. It should be enshrined in our Constitution, just so there's no further restrictions on it. But there was one clause attached to it. It said, subject to reasonable regulations. This proposal, how it's different than any other state, it goes the furthest of any of them so far. It specifically says, it shall be unlawful for the legislature to adopt any law which restricts the right to implement modern agricultural technology, absent a compelling state interest. How many of you guys understand what I just said? You got some of them? Okay. So some folks. So let's look at the first part of it, which is that there's a preamble, which is basically, we support the right for Oklahomans to farm in Oklahoma. Of course we all support that. No one's trying to take that away. It's that second part that's so dangerous, that the legislature shall pass no law. And what that means is not that just the legislature, but the agencies, that trickles down to the cities and city entities as well, like your water authority here in Oklahoma, or in Tulsa, excuse me, to your planning entities. It trickles all the way down. And the inclusion of that phrase, compelling state interest, that might sound like a good idea. Yeah, sure, that should be compelling. Health and water, those should be compelling state interest. That phrase is a legal term of art. And it was included because it's confusing. It's meant so people who aren't attorneys say, well, sure, a law should be passed with a compelling state interest. I think we all feel that way. But when it comes to the practice of law and the interpretation of law, compelling state interest is a specific standard that is applied in a constitutional challenge to a law. And what it does is automatically trigger a strict scrutiny standard of review, which is the highest level of review you can possibly have. So for example, there's been cases through the US Supreme Court that have rejected a compelling state interest for religious freedoms, for the ability to comply with certain planning laws. These are strict standard reviews where things you usually would think would be kind of a compelling state interest have not been found to be a compelling state interest. So see if we're trying to challenge, say, how water waste management is handled from a large chicken facility. Well, at that point, trying to get that through a strict standard scrutiny review, say that 6 times straight, trying to get it through that is almost impossible. And any attorney worth their salt is going to tell you the same thing, that this is specifically written so we're no longer going to have the power of our people, of our democratically elected representatives, and our appointed agency people to make laws for the foreseeable future. It's now going to go to the courts. The courts are going to be dictating agriculture policy. That's a major, major issue, and I think most of y'all would disagree with that treatment. The folks who are supporting this also like to say that this gets the state out of our business. I'll tell you what, the state goes out, who comes in?
That's right.
The federal government. There is no absence, there's no vacuum of regulatory authority. Someone is going to come in and regulate. So if you prohibit the counties and the cities and the state, the feds are going to come in. We have a legal analysis. I highly encourage you to visit our website called okfoodfarmfamily.com. You can also go to votenosq777.com. It'll direct you to the same place. We've got a legal analysis on there. It's a brief 40, 50-page read, just some light bedtime reading. But what it demonstrates in there is that this impacts our ability to protect our water. And that's the major issue. My cities are really, really concerned about this because you have the Federal Clean Water Act, for example. Well, as part of the Clean Water Act, we have minimum water quality standards that we have to comply with. Under 777, if we were trying to adopt new standards to comply with the federal rules, we would not be able to because it would be viewed as a restriction on modern agricultural practices. So right there will jeopardize our ability to run our own water quality programs. And who comes in again? The EPA. That's right. So anyone who tells you otherwise has no factual basis for that. We can provide you with legal briefs. It's all on the website. So water is the big issue here. Cities, the reason they're so concerned about it, right here in the city of Tulsa, you guys should all be pretty sensitive to this. You know, we've been in 16 years of litigation with Tyson Chicken and the state of Arkansas because of the level of pollution that's gone into our watershed here. I'm from Tulsa. I went to high school here. I was around all this. I used to go to the Illinois River and swim in that nasty turquoise water. And now it looks a heck of a lot better because there's been extensive cleanup efforts and lawsuits. None of this would be possible under 777. It's an absolute shield from immunity or from liability, and then it ties the hands of our water entities to implement regulations. So for example, the TMUA, the Tulsa Municipal Utility Authority, which is responsible for providing us with clean water and abundant water. Well, they're opposed to this bill. Lauren Brookie, who's the head of that board or commission, wrote an editorial in the Tulsa World back in March, demonstrating that State Question 777 would tie the hands of these water utilities to protect our water, to make sure that it's clean. Because any time you try to restrict, say, runoff, agricultural runoff, which is a pollution form, then bam, that rule would be challenged as unconstitutional. Where would we end up? Court. And then we turn it over to the judge again. This is a lifetime amendment to our Constitution. It means that we take a freeze frame of what we have right now, agricultural technologies that we may think are great right now. Remember something called DDT? Well, DDT for 50 years was thought of, hey, this is fantastic. You know, it's a great herbicide and pesticide. Well, then we find out that it's killing us. It's killing our aquatic species, killing our animals, and it's killing us, and, you know, most importantly. So we regulate it. We limit its application. Under 777, if we determine that a certain fertilizer or a certain practice is detrimental to our health, safety, and welfare, hands are tied. We have to go through court. We have to be able to respond effectively and efficiently as a government. It's the reason we have representative democracy. It's the reason we have agencies. And so when issues come up, we can attack them with sound science and policy and address those issues. 777, we've been in court 16 years on this water litigation. How long do you think it would take to get one proposal through court? We're talking 3 to 5 years minimum. So every time we're passing a law or regulation that could be seen as impacting agriculture, out to court. So I purport to you that this is a solution looking for a problem.
That's the way we usually do things.
Absolutely. Absolutely. So there's several things I want to say here. The Right to Farm initiatives, just a little bit of history here. These started out of this bill mill in DC called the American Legislative Exchange Council, which is funded by the world's largest corporate entities. And they put out model legislation every year on a variety of issues, but are usually directed towards corporate welfare and getting away regulations from their entities.
Well, that's ALEC, right?
ALEC, yes, absolutely. So these started in the mid-90s, early 90s, and the original Right to Farm, the first time the sky was falling, it was to get an exemption for farms from nuisance lawsuits. So Right to Farm was adopted in all 50 states in 1996. And at that point, what it says is that if I'm Bud Scott's farm and I've been raising pigs on my property for 50 years, and then you move in next to me and you put in a residence, you can't sue me because, you know, my property stinks so bad, or because I've got water leaching onto your property. You can't sue me unless I've been proven to be completely negligent. So it was a shield of liability for the family farmer. That's okay. So that was the Right to Farm that exists in all 50 states. There is a right to farm. My farmers will tell you, hey, I've been on the same property for 3 generations. I've been farming just fine. I don't need a constitutional amendment to tell me that I have the right to farm. So it started with ALEC. There's been 2 states that have adopted this constitutional amendment. You have North Dakota, which passed it first. Now there's a tremendous difference between North Dakota and Oklahoma, because in North Dakota, they do not allow for corporate ownership of hog farms or dairies. It's prohibited by their constitution. So when they adopted this right to farm amendment, it also didn't include that compelling state interest language. That's that big kicker. It did not include that. So after they pass it, what happens the very next year? The ag lobby's out there pushing for corporate ownership of hog farms and dairies. So they want that exemption. So this legislative session, there was a vote of the people in South Dakota or North Dakota, and they voted down the push to allow for corporate ownership of hog farms and dairies. So there's a big difference between what you see in North Dakota and what you see here in Oklahoma. Now let's go to Missouri. Missouri is the most recent state to adopt it. They also didn't have the compelling state interest language in theirs. So again, very different things. They adopted theirs and went to a recount. It was so close that it went to a recount. And it's been implemented there. It's been in place for about a year. There's already legal challenges popping up. So we're already seeing the impact. People are going to court. And they're going to court over the craziest stuff. There's this guy growing marijuana in St. Louis, and he says, he gets popped and he says, whoa, 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 whoa. So under this right to farm, so you shouldn't be able to regulate me, right? And of course it doesn't work because marijuana is classified as a Schedule A drug by the DEA. So, but once it's reclassified, so which very well may happen during this latest term of Obama, once it's unclassified as a Schedule A, then people could make that same argument here and say you can't even implement rules and regulations because it's an agricultural process. It would be the Wild West, which some of my clients would be like, yeah, that's great. So those are some of the points with the ALEC issue. In Nebraska this session, they've been pushing the right to farm as well. And Farm Bureau is the main supporter of this push nationally. In Oklahoma, it's a very corporate entity. In Nebraska, it's a little different. So they started to see the opposition to it. And the sky isn't going to fall on Nebraska, apparently, because they withdrew their push for this right to farm. And the president of the Farm Bureau in Nebraska says it's not a priority for us. So how can it be the sky is falling and American agriculture is so under attack by animal rights organizations, at least in Oklahoma, where there's been 0 proposals for it, but in Nebraska, it's not a priority? The two don't jive. It shows where they can get the race to the bottom the first. And in Oklahoma, we were all too happy to hand out those corporate welfare interests. So again, those 0 proposals, one of the big impacts that we talk about amongst the city people, and we're the folks that are going to be impacted by this the most. We go back to our water quality. We're paying millions of dollars for our water treatment systems. Most cities and towns can barely keep up with EPA regulations and requirements for, all bromine, all the different kinds of chemicals that are in your water system. They can barely keep up. Under this provision, what happens if we pass this and we can't regulate the amount of agricultural waste that's going into our water supply? That means how many of you end up paying higher rates because we have to charge more to make our water treatment system more effective, to add more chemicals into our treatment system. So all of a sudden, everyone's paying an extra $50 a month on their water bill because we have to treat this so much more. I'd like to do a comparison and see pre-Tyson chicken pollution of the Uchee-Spavinaw Reservoir here, what our water bills looked like and how much treatment we were requiring, and then now. I guarantee it's a big difference.